Good morning. Today, our topic of discussion would be the cause of action. Candidates who are appearing in the judicial service examination or the advocates who are dealing with the civil litigation must know what the cause of action is and what is the role of the cause of action. I will not take too much time. I will just brief you that what the cause of action is. As you know, the right to have a remedy arises only when a cause of action arises. So first and foremost question is what the cause of action is. So cause of action is a bundle of facts which either shows that your right has been violated or there is a threat perception of your right being violated. Suppose a boundary wall is there between your plot and your neighbor, and your neighbor want to demolish your wall. He is threatening you. So this entire episode, when he threatened, how he threatened, before whom he threatened, would constitute a cause of action which gives rise you a right to approach the civil court to to take an injunction against your neighbor that he should be restrained from demolishing your wall. Suppose he has already demolished, then you may file a suit for the mandatory injunction to restore it back by the defendant. Cause of action is like a root of a plant. The entire litigation rests upon the cause of action. So in trial courts, the cause of action must be clearly mentioned in the plaint. What will happen if the cause of action is not mentioned there? And what will happen if the cause of action doesn't arise? Two things may be there with regard to the cause of action. The effect of the non-disclosure of the cause of action is given under Order 7, Rule 11, where the plaint can be rejected on the ground that no cause of action has been disclosed. Remember to note that non-disclosure is the ground. If you have disclosed the cause of action, then Order 7 would not be applicable and suit can never be rejected, though you have mentioned a very flimsy cause of action. It may not have arisen in reality. So irrespective of the fact whether the cause of action has arisen or not arisen, disclosure or non-disclosure would be material one. Because how the court would come to know whether the cause of action has not arisen? Court will come to know only after the trial, because it would be a question of fact to be determined when both the parties are given evidence, and then court may decide. On final hearing, when suit is to be disposed of, court comes to the conclusion that no cause of action has arisen. The natural consequence would be the failure of the plaintiff in his suit and the dismissal of the suit. But at an early stage of the early stage of the civil litigation, pendency of the suit, it cannot be held that no cause of action has arisen to the plaintiff. So these are the effects of the non-arising of the cause of action and the non-disclosure of the cause of action. Order 2, Rule 3 talks of the different cause of action against the same defendant, and it permits the plaintiff to unite two or more cause of action against the same defendant. But Honorable Supreme Court recently, on the 15th February probably, in B.R. Patil versus Tulsa, Honorable Justice K.M. Joseph and Justice Rikesh Roy interpreted this provision that for one cause of action there must be one suit, meaning thereby for different cause of action the suits must be different, though the parties may be common or some of the parties may be common, because the consequences of mentioning of the cause of action are very important. Why? Cause of action will decide against whom the suit is to be brought. The cause of action will decide what remedies the plaintiff should take. If plaintiff has not taken if not prayed for the reliefs, then the cause of action will decide that he will not further be permitted to take all those reliefs which should have been taken in in his suit if he has not taken. So no subsequent suit can be filed in respective of the other reliefs in respect of the same cause of action. So whatever reliefs could be possible in respect of one cause of action should be taken in the suit, and if has not been taken, then the result would be such that he will not be permitted to claim those reliefs by filing a separate suit to avoid the multiplicity of the suits. So this case law of Mr. B.R. Patil, as decided by Honorable Supreme Court, is a welcome step and will guide the litigants, the legal fraternity, that what is the importance of the cause of action and how a civil litigation should be litigated so that the fruits of justice are given to the parties. Thank you.